Well, he didn't have anything to write on, so.
Right. All right, ma'am, are you Lauren Bridges? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Bridges, in cause number 25, DCCR 0354, you are charged with a state jail felony offense of credit or debit card abuse, and that's from October 16th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine, follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Bridges is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing, and so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. I'm assuming, based on the plea agreement, that there's some type of history,
Yeah,
Mr.
Judge, I'm
Nichols?
showing, I think, 2 prior state jail probations that I don't see a revocation for. Looks like they were both completed successfully.
And Your Honor, I provided, we originally set for a bond here. I provided the court and the state with letters. There's 4 letters. She voluntarily went to rehab from August. She got out October 27th. She immediately turned herself in when she got out. And I have those letters. There's 4 different letters from, it's called Riverwalk Ranch. It's where she received her treatment. And of course, she got certificates of completion, things like that.
All right, so any objection based on all of that and the nature of the plea for a bond, a low bond or
No,
PR
no
bond?
objection, Judge. Yes, I'm one, Your Honor.
What was your drug of choice, alcohol or some drug?
It was alcohol, methamphetamine.
Okay. So here's what I'm going to do. I'm going to reduce your bond. I'm not going to make it a PR bond because I'm going to order a drug patch. I'm going to reduce your bond to $1,000 based on the nature of your plea agreement. Condition of that bond is that you have to have a drug patch on within 24 hours of your release. So if you make the bond, talk to your bondsman, they'll let you know where to go get a drug patch on. Obviously, if you test positive for anything between now and sentencing, you run the risk of me not accepting this plea agreement. Things could be much worse. Also, if you make that bond, the first thing you do is go to the probation department so they can start that pre-sentence report. If you don't do that, you run the risk of me raising your bond and me not accepting the plea agreement. The last thing is that if you are arrested for anything between and sentencing, if you make that bond, obviously you run the risk of me not accepting the agreement. You understand?
Yes.
Okay, we'll see you back at sentencing. You can go back with the bailiff.
Thank you, Your Honor.
To have a mental examination, so he's in jail right now.
All right, sir, are you Travis? Hold on, are you Travis Smith?
Yeah, I'm good.
So I know there have been some documents filed by Mr. Adams with regard to a mental examination. I think there was some confusion as to what you're asking for. First of all, you're hired in the case, correct?
Yes, ma'am.
So anything that is filed requesting a court-appointed examination needs to include an affidavit of indigency sworn to. So I need you to get that taken care of and attached to anything you filed if you haven't already.
Well, it's not indigent, so we might have to
Okay,
go part of it. I'm not gonna follow that.
Okay.
For that reason, I mean,
okay. I mean, there are times when someone can
Yeah.
hire an attorney,
Yes.
but they run out of
Yeah.
money or whatever it is. If that's not the case and he's not indigent, then I'll reset the case to give you a time to have someone get that examination taken care of. But if it's a hired case and they're not indigent, that would be something that the defense would take care of. So,
Well, I
do you-
could still have, I think I have an order that would, allow that. Let me look through it here. I wrote the order different ways.
I guess what I'm saying is I'm not gonna sign an order having the county pay for it unless there is an affidavit of indigency.
I'm not asking for the county, that's what I'm saying, I have an order that, where we do it.
Well, I mean, I'll order it, but I don't know that you need me to order it. If it's your client, you can have him examined. Is there, you know what I'm saying? Do you need me to order it? If it's
No,
your,
I can get him examined for, it's present competency.
okay. But I don't think I need to order it. I think you can just have a doctor go, if that's
Or a
between,
PhD can do it too, I think.
yeah,
Yeah,
yeah. So I'll reset it to give you some time to get someone to go out there and take care of whatever examination that you need to, and then we'll get an announcement at the next court date.
okay, but what are we gonna, what I want after that is, to put him somewhere where he can't afford this.
Well, we gotta get the
State
examination,
hospital,
let's take
yeah.
one step at a time.
Yeah,
Let's get the
that's the second.
let's get the
Well,
evaluation
well,
done,
that's the
because if
first
he's
thing.
not competent, then I can order
Yeah,
him go to the appropriate facility, all right? All right, so you get the examination taken care of.
have to get you examined to make sure you're confident in what's going on, but mental health, huh?
A doctor is gonna come visit with you and just talk to you about your case and what's going on and make sure you understand everything, and then we'll go forward after that, okay?
I'm not understanding why we just with the case.
Because that's what we're gonna take care of. That's what your lawyer's recommending. So that's what we're gonna do. So you can go back with the bailiff. Mr. Adams, the quicker you get that done, the better, so that whoever's gonna do it can get out there and get that taken care of.